year, Dr. Eli Farhad Lateka, Senior Law Lecturer at the Tumaini University, Makerere in Tanzania. Dr. Lateka is a former Harvard Law School visiting scholar. And as we do in Vancouver, we sat out in the hallway and compared weather between Boston and Vancouver. We have the privilege of having our guest here until March 15, and I assured him that this is our typical Vancouver weather and not the weather that we had last week that was a bit more reminiscent of Cambridge than I would have liked. So this is what you'll get during your visit here. We do take some pride here at UBC of being an international law school, and you'll hear from this kind of short description of his resume and accomplishments that he has truly an international scholar. So as a Fulbright alumnus, he holds a doctorate from the University of Arizona. Between 2017 and 2019, he served as an expert member of the UN Permanent Forum on Indigenous Issues. He's also been a senior fellow at the Office of the High Commissioner for Human Rights in Geneva, and has guest lectured in several universities in Africa, Asia, Europe, and North America. He holds several awards from the USA, from South Africa, from institutes in Europe. And so really looking forward to hearing your talk both today and for hearing your contributions to the school over February and March. And so with that, please join me in welcoming Dr. Eli Farhad Lateka.
Thank you very much, Dean Pindell. And let me join you to also acknowledge the land, the ancestral and the unceded territory of the Musqueam peoples for whom I'm the guest today. And my presentation, as you probably have seen, is titled Legal Protection of Africa's Hunter-Gatherers Collective Land Rights. And that probably is the key word, collective land rights. And towards the end of the presentation, we'll see a case study of a group in Tanzania called the Akie, which is really less documented because other groups of hunter-gatherers have been really studied over time. And while preparing my presentation, I came across a quotation from a very, very noble and highly respected Nigerian novelist, Chinua Achebe, which I think really summarizes what I want to talk about. So I'll read it. The quote goes, "Man is a story-making animal. He rarely passes up an opportunity to accompany his work and his experiences with matching stories. The heavy task of dispossessing others calls for such a story and, of course, its makers." He goes on to say, "Let us imagine that someone has come along to take away my land from me. We would not expect him to say he is doing it because of his greed or because he is stronger than I. Such a confession would brand him as a bully. So he hires a storyteller with a lot of imagination to make up a more appropriate story, which might say, for example, that the land in question could not be mine because I had shown no aptitude to cultivate it properly for maximum productivity. It might go on to say that the reason for my inefficiency is my very low IQ, and explain that my brain had stopped growing at age 10. So that is Chinua Achebe in a book titled Home and Exile at page 59 to 60. And the key takeaway from the quote is that it's a very big task to dispossess people of their land and their livelihood. You cannot do that and they accept it to the reality to be portrayed as a bully, as a land grabber. You need to make a story that would justify, would lessen, that true picture. And probably, I don't want to draw a conclusion before the presentation, but probably that is the conclusion you may draw as well after my presentation, that these traditional communities in Africa, whose called the land, they depend on land for their, really for 100% for their survival. They are hunter-gatherers. But, the rate of dispossession is alarming. But such alarming dispossession is also really accompanied by very, very nice stories like, saving them from their own destruction and famine and, protecting the environment and so on and so forth. But really, I've structured my presentation in a way that I answer 6 questions. And the first question is, who are Africa's hunter-gatherers? As you have seen in the advert for my talk, these are traditional communities that predominantly make or collect wild fruits and hunt animals as the way of living, as a livelihood. And we have quite some notable examples, like the Hadza of Tanzania, because they have been quite researched. We also have the Batwa of Rwanda and Burundi and DRC, but we also have in Southern Africa, which is South Africa and Namibia and Botswana. We call them the San, or the Akie of Kenya, who have championed and really tried to oppose land dispossession in national and international justice institutions, and therefore they became very notable. As I said, predominantly they depend on land and its natural resources for their physical, for their spiritual and cultural survival as a people, as a collective. And in order to really practice their livelihood, they use the land communally. They are known for communal stewardship of the land, and they also have really deeply felt spiritual and emotional nexus with the land and its fruits. And unfortunately, I'll explain why unfortunately. They are also a numerical minority wherever they are found in the African countries, right? Africa is divided into a lot of borders, colonial borders, but wherever they find themselves, they are a tiny numerical minority. They therefore constitute the most vulnerable and highly marginalized groups in the continent. And due to linguistic barriers and because they live in remote areas, it is very difficult for them to integrate in policy formulation and also in drafting policies, even national visions. And therefore things are decided on their own. But really the main culprit is modernization, which is a development model that needs to modernize everything or quantify a livelihood in terms of how much contribution is made to the GDP. So that's question number one of really who hunter-gatherers are in Africa. And I must emphasize that they are predominantly hunter-gatherers because they have been forced really to opt other livelihoods in order to complement even food needs because of the level of land grab as well as factors such as climate change and so on and so forth. So you cannot really say they 100% depend on hunting and collecting fruits in the wild. The second question I wanted to answer is, why are their lands unsecured? Why is it that we say their lands are not legally protected? Of course, your guess is correct. The main problem is modernization. which is a development discourse. When planners in various African countries plan for development, they see anything traditional as a negative condition to be changed, right? So you cannot really convince a technocrat that you can practice hunting and gathering because they want to quantify and say how much will that contribute to the national GDP. So there's that negative stereotype already that this is a traditional way of holding land and therefore it has to be changed in order to contribute to the national economy. And in most cases, that has proved to be really disastrous because it reveals a very big rift between policy as it's officially formulated by uninformed technocrats, uninformed in the sense that they don't know, they have limited information about the traditional livelihoods and policy as it can be applied in practice. And because of lack of participation, and probably not only lack of participation, but goodwill on the part of the development planners, these livelihoods are fundamentally ignored, and therefore decisions of the government do not take into account that. But there's also something else. Researchers have called it Western legal thought. That our laws in Tanzania and probably many other former British colonial states have inherited the Western legal ideas and concepts. And therefore that becomes very hard because that is the starting point for planning. So development plans proceed from a faulty and questionable assumption that legal frameworks that facilitate individual ownership and land fragmentation are the solution to development. So we were all taught like that in our law schools, you go, you take a property law course, and, emphasis because of the legal heritage is on individual ownership and how sacrosanct that may be. But it really doesn't, go well with the hunters, gatherers. And this conceptual fault line is actually a reflection of the systemic and the structural efforts to force hunter-gatherers to settle down or adapt a sedentary life way. Because they are told that, this is a cake, it's useless, it is illegal. Sometimes they are, because, what doesn't fit the frameworks of the legal, the Western legal prism is regarded as illegal. So that is really the answer or the response to the second question. Why is it that their land is being taken at an alarming rate? Is because of a combination of factors, including the legal and policy frameworks whose base or vantage point is the Western ideas of empowering the individual to own land in order to maximize productivity. And therefore, the commons are regarded as really have a need, with a need to change them immediately. Another important question probably to answer at this stage is what are they doing about it, about land dispossession? And when I say what are they, I also include well-wishers, academics, as well as organizations or NGOs that have been formed to work for them. So in collaboration with the well-wishers, they have filed court cases, African hunter-gatherers, in national and international courts. And the most classic example is the Akie hunter-gatherers in Kenya, who have petitioned the government, appealed to religious institutions, accessed the UN, and even went to an international court in my own home city of Arusha in Tanzania, which is the seat for the African Court on Human and People's Rights. And when they filed a case there, showing that, thank you. So when they filed they won the case. And because they insisted that their culture and religion depend on access to their ancestral land. So they argued before the International Court, the African Court on Human and People's Rights, that there's no way they can practice their religion and their culture without access to their ancestral land. And in response, the court recognized the nexus between access to land and natural resources and indigenous cultural and spiritual rights. The court further emphasized the significance of collective land ownership to indigenous people's cultural and spiritual practices. So the court admitted that you cannot practice indigenous spirituality and cultural affairs without access to the land, which is owned collectively. The Ogiek further requested that the Kenyan government should demarcate their land and issue them with a collective title in the name of the community. They also wanted some compensation for their unlawful eviction. Fortunately for the Ogiek, they won the case in Arusha. And as I said, this is an international court. It issues binding decisions. It is contrasted with a commission which sits in Banjul, the Gambia. This is a court like any other. But unfortunately, up to now, the Kenyan government is yet to implement. So we have a really problem in implementation of decisions coming from the African court. That's number one. Secondly, the hunter-gatherers in Africa have made very, very useful access to the indigenous platform as developed under international law. So they have accessed the UN using the indigenous people's platform, which unfortunately stands to be very highly contested in Africa. So in Africa, governments oppose any identification. You cannot, the answer is everyone is indigenous to Africa because the reasons they give, and when I read these reasons, probably you can remember what the famous Nigerian novelist told us, that every dispossession must be accompanied by a good story. So these are the answers from governments in Africa why they don't want hunter-gatherers who survive on daily basis to identify as indigenous peoples and make use of the platform as developed under international law. African governments have raised questions about the usefulness of the concept of indigeneity and expressed the concerns that its application in Africa is likely to generate divisions, deepen ethnic tensions, and consequently cause political instability. But not only governments or policymakers, we also have some scholars. I don't know if they are the ones that Chinua Achebe refers to as hired story makers, but they conflate the concept of indigeneity or indigenous peoples in Canada, Australia, New Zealand, and the United States, the Kansas state, with what is applicable in Africa. Because, in those countries that I mentioned, it's very easy to see who is indigenous, who is not, because of priority in time, who was there before colonization. Now, that is taken to to Africa to discredit any possibility for communities on the margin to self-identify as indigenous peoples, right? By saying, oh, we are all indigenous to Africa. You know, after and before colonialism, we were all here in this land. But fortunately, the African Commission on Human and People's Rights, which is the intergovernmental institution, you know, mandated to promote human rights in the continent, went through the concept and came up with a report, which is the official report, saying, in fact, there are indigenous peoples in Africa and they meet the same qualifications or criteria internationally, and cautioned that unlike in the Kansas state, indigeneity in Africa is defined with reference to marginality, because there are communities that continue to be marginalized based on their livelihoods, even after the attainment of independence. But really, just to agree with Professor Chinua Achebe, I think there are lots of hired storytellers that would conflict in order to make it hard for communities to access this platform, which in my views and my limited knowledge of international law is quite robust in terms of protecting rights of community on the margins at the international scale. So contestation of the applicability of indigenous concept continues in Africa. And as I said, it reminds us of the Achebe's quote that I made. Another question is whose obligation is it is to protect collective land rights and natural resources, right? It is very important. Because probably one may think it is justifiable for a state to have a uniform way of accessing and owning land and disregard the traditional and indigenous ways of land holding. But the fact is, international law is very clear. I'll cite, for example, the United Nations Declaration on Human Rights, and Article 17 says, everyone has the right to own property alone as well as in association with others. And more importantly, it says no one shall be arbitrarily deprived of his property. So if you really read between the lines, the phrase that as well as in association with others speak to the possibility that some communities may own the land collectively, and we shouldn't just think that land ownership should take individual form. But we also have a very respected, highly revered scholar who served as a UN Special Rapporteur on the rights of indigenous peoples, Professor Anaya. And in his book, he says, and I quote, "In as much as property is a human right, the fundamental norms of non-discrimination requires recognition of the forms of property that arise from the traditional or customary land tenure of indigenous peoples, in addition to property regimes created by the dominant societies." So it appears, therefore, that if you disregard customary indigenous land holding of hunter-gatherers, you are offending in discriminatory prohibitions under international law, because discrimination is prohibited, and therefore by only emphasizing the mainstream way of land holding, you are practicing discrimination. But also the same applies to cultural integrity, and as an important enabler of cultural and spiritual connections of indigenous people. So as a general rule, we can see that one, land is protected, is a right like any other, is protected. But we can also see that land can be owned collectively. And once a state disregards the cultural and traditional land holding of hunter-gatherers, it negates and it violates principles of international law. Really, I like the jurisprudence emerging from treaty monitoring bodies. If you read concluding observations of the Convention on Elimination of Racial Discrimination, particularly, and the others, you can realize that when it comes to indigenous peoples, the supervisory bodies have indicated that land has an autonomous meaning, right? So the moment you are talking about land rights in connection to indigenous peoples, automatically you need to safeguard the autonomous nature of their land holding, the collective nature. And the same applies to cultural rights, for example, for indigenous peoples. It assumes collective nature. And therefore, we already have quite some rich jurisprudence emanating or emerging from very, very favorable interpretation of treaty monitoring bodies. But again, increasingly now, apart from states who have really the main responsibilities, transnational corporations also have some. They are expected to respect human rights, including rights of indigenous peoples to. For example, you may have heard already of the principles of FPIC, free, prior, and informed consent, that requires transnational corporations, before they go and access lands for development, they need to really consult indigenous peoples. And if that is done in good faith, I think it can lessen the possibility of interfering with the spiritual and cultural significance that hunter-gatherers attached to their land. Another question, where ideally should the solution lie? Is it a complex academic matter, or it may be solved? So ideally, and they say this is an academic, ideally this problem of disregarding land rights of hunter-gatherers could lie in having a sui generis instrument under international law, which protects collective land rights of indigenous peoples. And those who are familiar with the intellectual property regimes under international law, they know that the ideas of a sui generis instrument are not new. They are quite pronounced in that area because of incompatibility of indigenous people's traditional knowledge and cultural expressions with the Western benchmarks of protecting intellectual property. So in WIPO, the discussion is how can we have a sui generis, a very unique instrument under international law that is dedicated to protecting traditional knowledge, right? And therefore, ideally, an academic, a forward-looking academic would think about that for land and say, why don't we have a sui generis international instrument for the protection of land rights of communities on the margin who own and use the land collectively, and therefore is incompatible with the property law issues that we learn in law schools. But that is really overstretching the possibility of it happening for a number of reasons. And for the sake of time, I will mention two. One is the friction between that idea and the principle of permanent sovereignty over natural resources under international law. So international law allows the states to decide what they should do with their natural resources within their borders. And the global south, this is a very big deal. I've supervised the postgraduate studies for the last 10 years, and every year you find a student, doing something about permanent sovereignty over natural resources, because in the global south is a big deal, right? How a state should not be interfered with how it uses natural resources, and therefore an idea that you should have land governed under international law may offend that well-settled principle. Another challenge for Africa, at least, is that an international convention, which almost does what I said, called the ILO, the International Labour Organization Convention 169, remains largely unratified in Africa. So we have 54 countries, and only one, the Central African Republic, has ratified. And therefore, issues of having a supranational law, an international law governing natural resources is quite alien in Africa. Another reason is that the UNDRIP, the United Nations Declaration on the Rights of Indigenous Peoples, while it's comprehensive, and I don't want to go into the debate of whether it's binding or not, but it requires implementation plans, which is lacking in Africa. No country in Africa has some plans on how it can implement the UN Declaration of the Rights of Indigenous Peoples. Of course, as I said, even pronouncing, accepting that there are indigenous peoples is still quite a big problem. Maybe the other question is, the other solution could lie, we said, of a sui generis instrument under international law, probably under the local law should have a specific legislation that protects collective land rights alone. And it has already happened in a country called Congo Brazzaville, where they have a specific law that says this is how collective land rights of communities on the margin who are hunter-gatherers should be protected. The other question is, how can they reach that desired end, however academic it may sound, of having a sui generis instrument under international law, of having specific legislation domestically that dedicate or protect their land? I think is to have bifocal strategy, which means having domestic and international advocacy for reforms in order to really embed collective land rights under the laws because of the cultural and the spiritual significance that these communities attach to their land. And in my views, the Indigenous Peoples Platform remains key despite contestation in many African countries, because the international law and under the UN framework, it allows indigenous peoples from across the world to leverage some solidarity, gaining experiences and really forge ahead, because they have common challenges regardless of where they live in the hemisphere. And very quickly now, let me reflect what I said with the Akie of Tanzania, the hunter-gatherers in Tanzania called the Akie. Mind you, we have a lot of hunter-gatherer groups. Most notable are the Hadza, who have been really so much researched, and the Akie, who are only less than 500 countrywide. So despite the fact that Tanzania prohibits disaggregation of data based on ethnicity or religion, but research data indicates that out of 60 million people, the Akie, who was the subject of my study, are only less than 500 countrywide. So they are a numerical minority. And their land is really highly encroached. and they are subject of very, very severe stigma from the neighboring communities and even some legal and policy frameworks. I'll skip that. But really, despite a lot of stigma, they still try to live land, collective, to own land communally, and the land to them has enormous spiritual and cultural significance. And one anthropologist has studied that the community, and he associates persistence of cultural uniqueness as a conscious act to mitigate against the dangers of forcibly settled life, right? So it's a way for them to consciously portray that they are unique, and therefore they deserve some protection of their land. But really quickly, why are their lands taken? Why is it that they are losing their land rights at an alarming rate? The Tanzanian legal frameworks on land rights do not protect collective land rights of the hunter-gatherers. And I have examples. For example, it does not protect sacred sites from the concept of willing buyer, willing seller. So someone may go to a sacred site belonging to the Akie and put a resort for tourists, and the law doesn't prohibit. And these are communities that do not have money, so they can be lured, and the law doesn't protect them at all. Another is villageization program that took place in 1974. It remains a towering example of government settlement program that severely affected the Akie hunter-gatherers. What happened is that the government passed a policy and said, in order for us to bring development, to provide social services, everyone should be moved to one place, and they created villages. But in the course of moving people, they took small-scale farmers, they took cattle headers, and gave them land that was used by hunter-gatherers to hunt sustainably and to look for wild fruit. So that really is the DNA of all the problems that they have for now. Because that land, which was formed the village, was a traditional foraging land for these communities. And what are the impacts? Number one, language extinction. 2 months ago, I was in the village in meeting them, and they told me they only speak Maa, which is a language spoken by the Maasai cattle headers who have really encroached into their land. And, so because of the nexus between language and land, the indivisibility and interrelatedness of human rights, they are fast losing their language. But another is their cultural and spiritual integrity is highly affected and undermined because sacred sites are bought and converted into cornfields or grazing lands. So it was heartbreaking when I went and they were showing me a massive baobab tree where they go and pray. But now it belongs to someone else where he grows corn. Would just occasionally allow them in, but it's no longer they are collectively owned or communally owned land. Another is poverty. Poverty is escalating because they cannot even really afford and climate change and so on and so forth. But really, as I conclude, what are possible solutions now at the country level? This is ongoing work, but I came up with 4 solutions. One is, of course, to have a specific or a sui generis protection in the form of a different land category. For the sake of time, I should just mention that in Tanzania, we have three categories of land. One is a general land, which is available in urban centers and cities, and ownership is marked by having a certificate. Another, we have reserved land, which is really set aside for the protection of wildlife and forest and so on. And the third one, we have village land, which really is a problem now for hunter-gatherers because their traditional institutions and leadership is collapsed. They are forced to belong to an entity called the village in order to have their land protected. And therefore, my work is proposing that there should be the fourth category of land to be called community land in order to better protect rights of communities that do not necessarily belong to the village. And actually belonging to the so-called village is to their disadvantage because they are put together with other land users whose objectives are antagonistic to theirs. I will explain briefly. If, for example, you say hunter-gatherers should be in the same village with cattle headers, pastoralists, or farmers, in a village council, in a village meeting, they can democratically pass a resolution for destroying forests where hunter-gatherers collect fruits and medicinal plants and convert them to farmland. And therefore, it only makes sense to have their own category of land and protect it without forcing them to belong to the village. Another, I think, is there should be a legal prohibition against selling or buying of sacred sites. The other one is ratifying ILO 169 and implementing the United Nations Declaration on the Rights of Indigenous Peoples, because I think these two international instruments contain some important and comprehensive ways of protecting rights of communities on the margin. But lastly, there's also a need to address negative stereotypes that permeate the legal and policy frameworks. And unfortunately, it also identifies neighbors of the hunter-gatherers. So you are actually seen as wasting time. You need to evolve to graduate from the level of being a hunter-gatherer, and then you become a pastoralist, and then a farmer, right? So I think it's important to indicate that those are livelihoods of options, of choice, and they are protected under international law. Thank you very much for your kind attention.
Thank you very much for a wonderful lecture. We're in the Q&A portion now. I'll take the speaker's prerogative, just to ask the first question, if I could, which is, so as I listened to your talk, you described a large problem in a number of scales. In other words, you introduced us to a number of hunter-gatherer communities that were quite small. And I was struck by the less than 500 in a bigger community of millions. You talked about the state, right, and the state's relationship to these communities. And we talked about international law and some of the limitations, the possibility of international law, but some of the tensions between the implementation of international law and state sovereignty. So I wondered if there was any discussion, academic, legal, or otherwise, or any promise of another scale, which is a regional scale, in which some countries might have similar traditions or communities or populations of hunter-gatherers, notwithstanding the challenges of language and distance, but instead of international versus states, there could be collections of states with some similar cultures, and therefore some collection of hunter-gatherer communities that might be able to exert a bit more influence than individual communities.
Thank you very much, Dean Pindell. Yes, I can agree. We have some best practice, not necessarily about hunter-gatherers, because really the remaining hunter-gatherers, in the strict sense of the word, are in Africa. But in Latin America, there's quite robust protection of indigenous people's rights, including their collective land rights. And one indication is the rate at which the International Labour Organization Convention is not only ratified but also domesticated. So in terms of some lessons, Africa, if willing, can draw a lot from the practice that is now widespread in many countries in Latin America.
Yeah. Yeah.
Thank you very much for your talk. It was very interesting. So I wanted to speak about the tension between dispossession and marginalities, different communities on the margins. And this is something that came up very strongly in the Lackawanna case in the Inter-American Court of Human Rights. This question of what states have to do with competing on their face, quite serious claims to different kinds of communities. And this has come up, I think, in the general comment of the Committee on Social and Economic Rights on the Right to Land, where there's some proposals in this context to try and reconcile different groupings who have legitimate claims to communal rights, who are equally dispossessed from the land in one sense, but they have different claims, they have different kinds of claims. And it comes up in your talk when you speak about the tension, the representations of African nations, trying to sublimate this category of indigenous to further their own claims with respect to development. But there is something underneath this tension, right? There's something about what do we do? If you look at apartheid South Africa, post-apartheid South Africa, where I'm from, there are genuine tensions between those communities who've been utterly dispossessed of their properties and lands and their cultural practices through that, and what we might see as the Nama or the San, people who have different kinds of relations to land. So in the village, where you speak about this category of village land and these different politics, it's a very interesting tension. And I wondered if you have more to say on that.
Yes, thank you very much. At the moment, international law tries to address that by using the concept of free, prior, and informed consent, which is still in the formative stage, really. We have advanced this so much as international lawyers that we can make PowerPoint presentation about FPIC, but how it applies on the ground is still quite a task. But what it means is that really, if you want to use the land belonging to communities, you need to get their informed consent. They should allow you to do that. And there's discussions whether that gives them the right to veto, and because that, as you said, would complicate the role of the state and how it can really harmonize or reconcile rights of different groups. And there's no conclusion about it now under international law, but there's overwhelming consensus that FPIC is key in removing or lessening the tensions and a sense that land is being grabbed without the communities agreeing. And just a footnote to that is that international human rights law addresses the weaker part, right? Because the assumption is that the stronger part is taken care already, and therefore the indigenous people's platform, as well as the free, prior, and informed consent principle, is really aimed at leveling the ground. So you cannot really be afraid that it may be a problem to reconciling different competing groups, because the intention is to bring indigenous peoples to the same level as the mainstream communities, and because of the historical problems they have undergone for many years.
I'm Doug Harris, a faculty member here. I was really struck with your opening and your use of Chinua Achebe and the importance of stories. Right? He's one of the prominent storytellers about the collision of modernity and traditional societies. And he's telling those stories to explore that collision, not to justify the triumph of modernity, but you're really using that in interesting ways to explore the stories that are told that attempt to justify or legitimize the triumph of modernity. And one of the stories that you told that's used is of the power of private property to empower individuals to build economies. And maybe one of the chapters that's commonly part of that story is the importance of the formalization of title or title registration. And here I think in particular Fernando de Soto and others who have said it's not just private property that's important, but it's these structures for formalizing and registering title that are important. And I'm wondering if that chapter of the private property justifying, legitimizing story is a feature in the communities and the loss of land and their loss of land that you're telling. Is that formalization of title an important part of the justifying story that's going on here?
Absolutely, spot on, exactly. That's the lifeline of the dominant story of dispossessing the communities of their lands that is collectively owned. And you can even go back, apart from Hernando de Soto, most of you may have read about the tragedy of the commons by Hadin, who said, okay, you need really to subdivide and give, otherwise if you leave it for the commons, it is no one's business, it's not protected. And I think that has become the 11th commandment for planners in Africa, right? They think, how can you be pastoralists? How can you be hunter-gatherers? We need some formalization of titles that empower individuals so that they can even access bank loans. But we think, and I totally am in agreement with Professor Achebe, that those are just stories to justify. Because if you examine them carefully, those measures do not in any way protect the land. They take the land away. So it turns out that the problem of formalization, unless it is formalized in a sui generis way, in a very unique way of empowering traditional authorities and allowing them to manage land using their own customary laws, is just a land grab of another venture. It's just entrepreneurship of land dispossession done by the government.
Thanks very much, Professor, for your lecture. I just had a question about the role of sovereignty. And so the types of land ownership you describe brought up the question for me, sort of what's the ultimate source of sovereignty in the systems you're describing. I come from Ghana, where it is recognized that the state is not the ultimate sovereign in land ownership. And so the only entities that own fee simple absolutes in land are stools, skins, and families, which are sort of which are held on behalf of communities. And so any purchase or licensing or registering of land is recognized as only a second level ownership, which reverts back to the stool, skin, or family after a certain period of time. And so it seems to me like these countries have systems where sort of, instead of the kingdoms or the families or the tribes which preceded colonialism being the ultimate sovereigns that own the land, it seems like the state has taken over as sort of the ultimate sovereign, which determines what land is used for, even when the traditional rulers do not agree with that movement.
Yes, thank you very much for a very important question. I totally agree. And if you make a very simple, really a cursory study of jurisdictions and compare how land is owned, you'll realize that they probably three ways. One is a fee simple, where your land is yours, the state has no problem, cannot do anything about it. But the other one is where the state dictates. And then, of course, the third one is a hybrid of both. And my little knowledge of African land holding system really has embedded the colonial concept of a radical title, where the state is regarded as having the final say, right? In my own country, for example, it's considered that you only have the right of occupants, but the land belongs to the public and it is under the president as a trustee. And because of lack of a clear understanding of what that means, the state can really abuse that concept of being the custodian on behalf of the general public. And I think this is another call for decolonization of land matters, because it was made this way to facilitate colonialism. And now that, many academic discussions are geared towards decolonizing, I think it's high time Africa also rethink how really to blend the need for the government to be on the driver's seat in the terms of really overseeing land management and distribution, but also giving them, the communities, some autonomy in how they plan their life and be able to protect the land in court without reverting to the radical title and say, at the end of the day, the government can decide whether to take it or not. So some sort of a hybrid of a fee simple and a right of occupancy conception.
So let me take a question online, and then we'll come back to the room. So the question is, so since court orders, and one of the examples she gave was the African courts are not enforced, what do you think is the role of alternative justice systems in ensuring the rights of indigenous people in Africa?
Good question. In fact, we do not want to convert international courts into white elephants. So I still think they are very important institutions, and the indigenous people should continue accessing them. And the fact that in Kenya, for example, the indigenous communities won key cases in Africa and they are yet to be implemented, I think I would be optimistic and say is a matter of time. Probably a change of government may see that implemented. So I think it's important to have alternative dispute resolution, but because of the nature of government, something binding is important. I think jurists had to really design and recommend that we should have regional human rights courts like the Inter-American Court, because of really the danger of entrusting human rights to a state alone. So I'm a very big fan of the African Court, and I think non-implementation of the two cases from Kenya should be seen as an exception rather than the general norm.
Dennis, did you have a hand up earlier? Yeah. Yes, so you're there, and then you'll be next.
I'm just curious. I mean, you paint actually a pretty dismal picture for nomadic people, but there seem to be some light, if I heard you correctly, in Congo-Brazzaville. And I wondered, are there legal mechanisms or constitutional mechanisms that have been put in place to somehow make indigenous people more successful or happier there? Or is it just sort of like a benign bureaucrats who are tolerant of this? What makes Brazzaville, why is that having some success?
Very good question. In fact, some academics theorize, and I don't think it should be taken as the ultimate truth, that they were also reclaiming a good name under international law, having gone through some wars, and so was also a good way for the government to really get the attention of well-wishers. But secondly, I think the Central African Republic has quite a sizable number of hunter-gatherers. So it is important for the government not to ignore them entirely. I think the most important part of your question is whether that has changed in any significant way the constitutional way those rights are seen, and not quite. I was in Congo Brazzaville some years ago, and they're still really thinking how to effectuate that. But is a cause for celebration among international lawyers in Africa that at least it shows that some countries are forward-looking, and if the international law works by states copying from other states, then we already have an exemplary state which can really convince others to do the right thing.
Thank you very much for your talk. As someone who's both Indigenous and non-Indigenous here in Canada, your words are very inspiring, but I fear that a formalization of the recognition of Indigenous rights may lead to greater conflict. We're very familiar here in Canada with the desire for land back. This would be land that's already been claimed by settlers, that Indigenous people are wanting returned to them, at least in some way. Perhaps not in formal title, but it's become a political issue. It's become a fight. And I fear that Indigenous people in African countries might see a similar thing, that they won't be able to claim their land or to be able to receive it back where it's already been claimed by somebody else in a very legal way. And how do you see ways, I don't know, to help us in Canada learn new resolutions, new ways of thinking about it, or to make sure in Africa in African countries, we don't see the desire to formalize recognition of Indigenous rights to land, but also greater conflict within the society?
Thank you very much. Really important question. Of course, I can't claim knowing, land issues in Canada, but I can say that even in Africa, it's quite some complex issues that require a very delicate balance. I'll give you an example. For example, the Akie people, even in Kenya, they were dispossessed of their land in 1974, so 40 years ago. And so restitution is almost impossible. The land has been converted into a reserve, and how do you do? So apart from winning the case, the court had also to deliberate on the appropriate, compensation. What is the reparation methodology that does not do more harm to a stable state than it aims to protect? So it's not a very simple issue. But one of the solutions is really not to claim restitution, but access to places of cultural and spiritual significance, for example, can be one of the ways. But secondly, co-management. So if it is a reserve, you integrate them and they get benefits accruing from them. But I agree with you, that is a PhD worth topic that really doesn't call for simplistic answers.
Last quick questions in the Karen, you'll get the last question.
No pressure though. Thank you so much for a wonderful and really inspiring talk. I was really struck by your idea of a sui generis proposal for Tanzania of a fourth category of communal lands. But I wondered when you were talking about the potential for the existing tensions with pastoralists and farmers. Were you contemplating this communal land category as something that was really focused on or limited to hunter-gatherer communities? Because pastoralists, of course, and I'm thinking of a place like Mongolia, where we have a PhD student working on pastoralist rights, are also under threat in other parts of the world. So is communal land something that would be specific to the highly vulnerable, marginalized peoples you've been dealing with here, or could it, and would it be understood more broadly?
Thank you very much. In fact, pastoralists are in the same category. And I must declare interest that I belong to one of the pastoralist group. I'm a Maasai, and there's quite a lot of contestation and a lot of land issues and the forceful evictions everywhere, based on different stories like, protection of breeding grounds and probably protection of other land uses like crop cultivation and so on and so forth. So probably that is a story for the other day. But for today, I zero in with hunter-gatherers, which for me are the most marginalized, because even pastoralists to which I belong are listed as encroachers. They also encroach land belonging to hunter-gatherers. So I think it's a matter of scales. But I agree with you. Pastoralists are equally vulnerable because their landholding system stand in stark contrast with the individual land ownership, the priorities of government for quantifying and getting GDP. It's a traditional livelihood that is at the center of a lot of stresses in Africa.
Thank you. Well, thank you for those excellent questions. And just before we wrap up, so don't clap just yet. We wanted to give you a small token of our appreciation. So thank you very much for a wonderful talk.
Thank you.
And we'll really enjoy your visit here at UBC.
Thank you.
Thank you.
Thank you.